You don't have it yet?
Somebody else? You gotta stop hitting people.
I don't have the Okay, do we have the sign-in sheet? And have you started the video recording? Okay, I'm gonna go ahead and call this meeting to order, and we'll start with agenda item number 1, which is the public comments, and the first person on my list is Tracy Brister, and she wants to make a public comment. Is she here? And you're gonna have 2 minutes. And, hold on, who's my timer? Okay, we got a timer. Jimmy will say when, how's that?
Well, forgive me, I'm not sure if this is the right place to be requesting this. I got a fine, for an incident that occurred, and I wasn't even in town during this happened. Someone parked and my brother came up to visit, didn't know about the rule, parked. I was down taking care of my mom, who was in the hospital. I didn't know about it. And there was no way for me to take any kind of action on this, and I make every attempt to follow all the rules. Keep my yard mowed. You know, I deliberately do not park on the street. I even requested a variance once because I needed to and didn't hear back from the management association, so I made other arrangements because I didn't want to break the rules. So I'm just requesting a waiver.
Okay, I guess what I'm gonna do is I'm gonna, Jimmy and Diana, would you please follow up on that, and then we'll take this out at the next GRC meeting, okay?
Yeah, I got the same issue. I'm contesting it. Y'all's fine too, so.
Okay, and that's fine.
Yeah.
When you come up for your, 2 minutes or whatever, we'll talk.
Oh, okay, I didn't know if I
Okay.
should tell them to.
So what process do I do now?
I guess at this point, what will happen is that, it's gonna go back to the DRC committee, and we will review what happened, and we'll
Do you need, I didn't just learn of the
We'll get
fine
in
about
touch
2
with you.
hours ago. So
Yeah,
who do
we'll
I
get in touch.
notify, the address and my name, all that? You got my name and address,
right, so we're good there.
Alright, I
Yeah.
don't need anything else from me?
No, you don't need anything else from us, that's fine. Okay, Rose, you're on the agenda tonight, did you wanna talk also?
Sure do.
You wanna make a public comment, and did you wanna talk to an agenda item?
I'll just talk about one.
Okay, so you're gonna make a public comment?
Well, it's having to do with that meter for my water.
Okay, so you're making a public comment,
I-
you have 2 minutes, go ahead and start the
I-
timer, Jimmy.
I do not know how to read that thing. I want my old meter back. There's not even a reading on my bill. So, what do we do about it? And I
Okay,
can't get anybody to answer at the office, so. That's right.
okay,
Okay.
yeah, I guess that's it, so, all I'm hearing is that you have a new meter and you need help knowing how to read
No,
it.
I want my old meter back.
Okay.
And I have that right to get my old meter back, so, now, I don't know, can I make another comment about a deed restriction or not?
Well, I'm just gonna consider all of this just part of your
Okay.
public comment, okay, that's fine.
Okay, because I'm about as ignorant about this as anybody is. I wanna know if an 18-wheeler enclosed trailer can be moved in our backyards. Now, I'm in section 1, question for me. Not a flatbed, this is completely enclosed.
So you wanna put a trailer, 18 feet, you said, or 18?
Well, no, 18-wheeler,
18.
but without the tractor, but it's not a flatbed, it's the enclosed trailer.
So it's a,
Is that
like a
legal?
53-foot,
Don't ask me how long they
is
are.
the long one?
Oh, yeah, an 18-wheeler, yeah, it had to be moved in with a semi-tractor. So is that legal in the backyard is what I'm asking.
I don't know the answer.
Backyard, that's what I'm asking.
Well, it can get in there. My son's got the equipment to lift it over the fence if he has to.
I'm not answering that question.
I don't know,
I
I
don't think
think,
we've ever
It's a
had
trailer.
anybody-
Bill, are trailers allowed in section 1?
Well,
On the property.
not the flatbed. Now, this is an
This
18-wheeler
is in the backyard.
boxed in.
What would be seen from the street though?
Yes. Oh, yeah.
Okay,
but
she's in
three-
section 1, section 1 is no
Three and a half
restriction.
foot above the privacy fence even.
okay, I think the best way to solve this is to go get pictures and then discuss this with legal counsel and figure out what exactly we have. And then we can get an interpretation as to, about that. I think that's the best way to
Yeah,
proceed.
because I don't know that it's in our deed restrictions to, that it would say specific what's going on there, but I wanna know it, because if it's gonna be legal, I wanna move one in mine,
Okay,
along my fence.
okay, Gerald, you're up, and I'm not quite following your handwriting. You say you wanna talk to agenda item 2?
So I'm gonna make a public comment,
Okay,
then I wanna discuss item 2, and then I combine those other three with one. I only
okay,
want 2 minutes for all three of them, because I wrote the comment and then it covered all three.
okay,
I didn't know which one to put it under. so-
okay,
So then I just wanna make one public comment and 2 agenda items.
okay, that's fine.
Go.
Yes,
Okay, some facts regarding director response lawsuit against the MUD and the Neighborhood Association. First quote, "It is therefore ordered, adjudicated, decreed that the defendant's plea to jurisdiction is granted. The case is dismissed with prejudice to refiling. This case is final disposition of the case. Judge presiding Jessica Mantrum. This means that Director Fox lost the lawsuit against the MUD and the Neighborhood Association. With prejudice to refiling means that she cannot in the future file the same lawsuit against the MUD or the Neighborhood Association again. Prejudice to filing is not about a legal standing in this case, as you asserted in the public comments 2 months ago. Also, the MUD argued both your lack of legal standing and the case law in its dismissal plea against your lawsuit. The judge did not delineate as to the reason for her decision to dismiss your lawsuit. Secondly, from one of my sources, I've requested copies of Neighborhood Association legal fees from their attorneys. The total cost incurred by the MUD for the Neighborhood Association was more than 25% of the MUD's total legal cost of your lawsuit, not the 50% you stated in public comments about 2 months ago. Third, all the funds used to pay for the Neighborhood Association's legal expenses incurred from your lawsuit came from fines, not funds collected from tax revenues. The Supreme Court has ruled that there is a legal difference between government fines and government collection of income tax. Therefore, no resident taxes were used by the MUD to pay for the Neighborhood Association's legal invoices, since those funds came from, they came from deed restriction fines. And that's it for public comment.
okay, so now you want to talk about agenda item 2?
Yes.
Okay,
So in the 20 years of the audit of the WTC MUD financial statement, by an outside accounting firm, no fraud has been found. These audits are conducted by CPAs with the highest. Director Fogg has publicly claimed that with the use of taxpayers' money, she has found fraud when researching the MUD's financial documents via her TOR request for MUD records. She's not a CPA, not an attorney, not a person accountant. So how is she able to find such crimes when no other professionals can corroborate those crimes? Have you shared your purported put through together. Step 5, 7, and 9. It's come to, I guess I should take this off. Here it is. It should come to the attention of Andersonville West ACC that many property improvements are being undertaken and completed without the proper approval process. And in some cases, they lack the proper requirements for an approval by the Andersonville West ACC, i.e. Whitaking project. It appears the MUD may obtain new legal counsel. The Andersonville West does not have any enforcement authority with regards to deed restrictions. We are looking forward to working with the new legal counsel, if that's the case, and the DCR to set the appropriate enforcement framework authority so that we can work together to resolve some of these issues. The MUD has spent a lot of money to save the Andersonville West DCC. It would be a shame to let that investment go to waste.
Okay, David Flores,
Thank you, Jasmine.
and you're gonna make a public comment, and then you're gonna talk about, 3 and 7?
That's correct.
Okay. Want to start with your public comment?
Yes, ladies and gentlemen of the public, I'd like to, for the people that are requesting, their fines be waived, they're gonna try to settle this outside of this public meeting. So I ask that you come back and report what it was that they decided, so it's on the record on what they choose to do. They are very bad at being transparent. So I asked you to come back and let the public know on what they decided, how they handled it. Because they pick and choose how they handle different, people depending on if you kiss the ring and bow to them or not. If you fight back, they tend to, target you and continually target you. You can have a neighbor with the same exact fine and the same exact problem, and that person will get away scot-free because they bow down, make arrangements, and kiss the ring. So I ask you to come back, let the public know exactly how they handled it. I hope that the council that takes this new position is aware of the lack of transparency that the public feels that this board has not been very forthcoming, so hopefully they know what they're getting themselves into. You gotta, whoever it is, you guys have a job ahead of you, and I don't envy you, but I look forward to working with you when in the future when I do win the election. That's it for public comment.
Okay, agenda item 3, interview of candidates responding to the RFQ.
Well, I guess I kinda touched on that, but I hope that the board, really listens to the attorneys that are applying for this position, and I hope that you don't have in your mind set on who you are going to pick. I believe Catherine is set on who she's gonna pick, from all the evidence and the meetings and everything prior to this meeting. But I hope that you listen to them and you make a great decision for the community, not for Catherine. I know she asked your allegiance, I know she said, follow me, but you are individuals that the people voted for you individually, not for Catherine, but they voted for you every single time you got elected. So I ask that you have your own mind, your own decision, and you don't get bullied and influenced by Catherine, that she tends to bully people into doing. Number 7, I got a letter from Sage Management the other day about an unregistered vehicle. I have a problem with them and the way they enforce. I know several neighbors that have classic vehicles that have been in their driveway for years, 2 to 3 years. And I have 2 classic vehicles in my driveway and in my garage that I constantly work on. You should take a look at their letter to the DRC committee. You should read it, because they said that I am allowed to have it. Look over their letters. You guys dropped the ball by letting that letter slip into my hands that says I am not allowed to have the car in my driveway without registration, and it's okay. So I'd ask you to look over that. If this is an indication of the way they handle their business and letting all these things slide and just the lack of professionalism that they have, it's pretty bad. You know, DRC committee never brings anything to the public that, oh, this has to be fixed, that has to be fixed. You know, we want transparency. We wanna know if they're performing. We wanna know if Infomark's performing. So, I'd take a look at that letter. You'd get a chuckle out of it. That's it. That's all I have for today. I appreciate it.
Thank you, David. And last, we have Ryan Hall.
Hell,
And did you wanna make a public comment?
yeah, it's about the fine.
Okay.
So we're talking about $150 for a trash can. I was specifically told twice to come to this meeting, and y'all could resolve that today. So, obviously I couldn't come to the 19th meeting, y'all had COVID, actually I had COVID as well. So that meeting was canceled, I believe, correct?
Yes.
Then I called back 10 times in a day, and I get a call at 10 o'clock at night, telling me I can come back today. So, and I was supposed to get resolved today, so all my $150 disconnect bill on my water wasn't resolved today.
Can I ask who said that it would be resolved today?
Sage Management. I got a phone number, I mean, she texts me and calls me from y'all's online number. I don't know her name, I can show you the text thread.
We have to take it through legal first. It can't, it's not something that you can just do right away.
Okay.
Yeah,
So, and we can't talk about it during a DRC.
I can't leave talking, I mean, $150 for a
Well-
trash can, it's not like it was on the curb, I mean, I added up the house. My wife travels for work, kids and softball and gymnastics, all this. I work sometimes overnight if I have to do lane, I own one company, so if we have lane closure, gotta shut down roads downtown and get into manholes. They've sent me letters about trailers, they take it 11:59 and 12:02, I'm there overnight. Well, I got a lane closure at 2 AM. Just there, and I'll drop it off when I'm done. Kind of a safety management issue, really.
Okay.
And years, 10+ years ago, when I came up here, they got rid of my fine right here in this very room.
I'm gonna be
So I
really,
can't do that, I just want it off my bill, that's all.
I'm gonna be really honest with you, Mr. Hall. I don't know what exactly it is, what your fine is off the top and all the particulars. So at this point, because we're in this middle of this huge, general counsel shift right now, we're just gonna take it back to the DRC committee and deal with it at that level, okay?
So when will I know?
I think that we agreed.
Cause I mean, I got this bill pending. I got a disconnect letter the other day, which I've never had in my life, I've been there since 2007.
Catherine, can you ask Mackenzie to take them off the disconnect list?
I already had to pay the bill because nobody would do that. So I just paid the $150 fine portion. So now I have an outstanding bill for a trash can out of the garage.
Okay, so let's just go ahead and make sure that he doesn't end up on the disconnect list again, and because we'll have this resolved
It's 1510 Brighton Bend.
until, we will have this resolved by the next month.
So y'all will contact me.
Yes, we will.
Okay.
Okay.
Catherine, is this the address that has 7 months between infractions?
I honestly do not know.
Would you please write that down and check when you do, because if it was, he shouldn't have a fine involved.
Is this your first notice? Have you had a notice?
It's the first time I've had a fine in years.
Okay,
Did you get a
so-
letter before, prior to that?
I don't know, I don't know, I don't do mail.
Okay.
Everything online.
That's part of the
Just
problem,
send me an
you don't
email.
do mail, which is why we're sort of throwing it, back to the committee with dealing with the, general counsel. Okay, I promise this will be resolved, okay?
Okay.
Okay. thank
Resolved
you.
in your road fine, that kind of law.
That's what we're trying to get to,
Okay.
yes.
All right, good, I like
Okay.
it.
Okay, so at that point, Mr. Hull, since you're the last one, I'm gonna close the public comments for this, at this time, and we're gonna move on to, agenda item number 2, which is the district's annual audit by Maxwell Locke and Ritter. I'm assuming that's what this is.
That's correct. So good evening, I'm Jimmy Romano with Maxwell and Ritter, and tonight we'll be going over your audit report for your fiscal year ended September 30th, 2021. Just wanted to point out to the board that there is one number that we're still trying to finalize in conjunction with cooperation with Infomark to basically make this document final. So you'll notice that's why at the very bottom, there's some language about it being a draft. So essentially tonight, we'll go through our presentation, and then based on legal counsel's recommendation, the, approval would be pending that resolution of that final amount before anything gets submitted and filed with the PCQ. So just want, and I'll point out where it is in the report once we get there. So if you wanna follow along, and also just to point out too, we did meet with both Linda and Megan last week and went through their questions, as part of their role as the audit committee. So that's always something that we do ahead of time before we meet with the full board to go through things in a lot more detail. That way, at this evening's meeting, our presentation will be a much higher level presentation of the financial statements of fiscal year 21. So we are issuing a unmodified or clean opinion for your financial statements for your fiscal year ended September 30th, 2021. If you want to turn in the audit report, we'll begin with financial statements, which begin on page 11. So on page 11, this is going to be your statement of net position and governmental funds balance sheet. The first column is going to be your general operating fund. At the end of fiscal year 21, had total assets of just under $3.4 million, liabilities of about $716,000 to arrive at an ending fund balance of just over $2.5 million. And you'll see down below in the fund balance section, that's where the two areas that are highlighted, that's the numbers we're trying to finalize, the beautification projects amounts. Currently, that amount is under, like I said, review and coordination with Infomark to get that number to where it was as of September 30th, 2021. So once that number is resolved, whatever modification is done to that amount, you'll have a corresponding modification to the unassigned amount. And as a reminder, the unassigned means it's available for general operations of the district.
And just for my clarification, all we're doing is moving money between the two highlighted, lines.
Correct.
We're not, so the
The
bottom
total number,
line.
yeah, the total number will not change. So whatever that HOA beautification project number ends up at,
Uh-huh.
that whatever change that is, it'll have a corresponding change to the unassigned, but yes, the total amount that's presented here will not be changed.
Jimmy, let me just, make it real clear. This isn't beautification projects, it's the beautification fund. Is that correct? That is the fund that was used to pay legal fees for a private entity. Is that correct?
I believe this year there were.
Okay, so that's what you're gonna fix, is this number here. So this isn't beautification projects, it's the beautification fund that comes from money collected from deed violation fines, right?
Yes.
Thank you.
Okay, and then your second column is gonna be your debt service fund. At the end of fiscal year 21, you had about $123,000 of fund balance that's restricted for your principal interest payments on your outstanding debt. And then as a reminder, the very far column, which says statement of net position, this presents information on your financial statements in a similar manner as a for-profit entity would show their financials. So the main items that are presented here that aren't shown up in your funds are gonna be your capital assets and your long-term liabilities, so your long-term debt. Moving on to your next page, page 12. This will be your statement of changes in fund balances during fiscal year 21. Starting with your general fund, total expenditures were just over $4.3 million. Total revenues were just under $4.4 million, so a net change in your general fund of about $36,000 increase during fiscal year 21. For your debt service fund, net expenditures of just under $375,000, revenues of about $305,000, so a decrease of about $69,000 in your debt service fund, which is expected because you are paying down your bonds. So obviously the tax rate allocated to your debt service is gonna come down as well, so you don't have any really remaining funds left once those remaining bond payments are paid, because those funds are restricted for principal and interest payments.
Okay, so just let me ask a question, so when we, I think we got, it's not, one more year after the current.
It's 2 more years.
2 more years?
22 and 23, you have principal payments.
Okay, so when we make that final payment, will, that final payment will zero out that account line then?
More than likely, you may have a little bit of residual funds left over in your debt service fund. And I know once that happens, we don't have a lot of our districts that basically have no debt service fund. We have a lot that still are paying off off debt. But I believe, and legal counsel will definitely be able to help you with this, I believe if you have no more remaining debt and you do have funds that are left there, there is a way to petition to be able to get those transferred over to
Okay.
your general office. So you won't lose the funds.
Okay, that
It's
was
just,
my
there's
next
some
question.
there's some more things you have to go through. So that's why with your financial advisor, when you're setting your tax rates, the debt service rate is key to make sure you kind of think about that, because you don't want any more in there than you need to make sure you can service your outstanding debt payments in the next
Okay.
couple
And that was the point I was gonna add, your financial advisor looks at that every year, that's part of her plan, she'll try to set it so it gets close as possible, but
Okay.
still you have to guess, you don't know what people are gonna pay.
So moving to the next page, this is gonna be page 13. This will be your budget actual comparison for your general fund. If you look at the very far column on the right, you'll see you have a positive revenue variance of about $266,000 compared to budget, a positive expenditure variance of about $270,000 compared to budget. So overall, positive budget variance of about $536,000 in fiscal year 21. And then beginning on page 14 are gonna be the notes of the financial statements. As part of the audit this year, there were no new accounting or auditing standards that were implemented, so the information in your notes will be very consistent with what's been included in your audit reports in prior years. So I'm gonna just touch on a couple of items real quick in here. I'm going to skip ahead all the way to page 23. This will be your long-term debt footnote. So as you can see, in fiscal year 21, you actually paid off the remaining balances for your Series 2005 and 2011 bonds. So the only bond remaining is your Series 2003. And at the end of fiscal year 21, you owe $360,000 of principal, which will be paid in fiscal year 22 and 23. So that's shown on page 23 as well. Beginning on page 26 are gonna be the required TCEQ supplemental schedules. And the one schedule I was gonna discuss with the board tonight is on page 33. This will be your outstanding property taxes as of the end of fiscal year 21. So if you go towards the bottom of page 33, under the 2020 column, and as a reminder, your tax year is always 1 year behind your fiscal year. So your 2020 levy, as of year end, you had collected just under 99% of your outstanding property taxes. So more have obviously have come in since then, so still very strong collections in your property taxes during fiscal year 21. And just as an overall note, as part of the audit process, we definitely want to thank Infomark for all their assistance. We had no significant audit adjustments as part of our process this year, and no significant disagreements as part of our process as well.
Okay, I want to ask a question about page 8, and you might not know it, but maybe Martha does. And
Page?
Page 8. And what really, when I was going over this, one of the things that struck me was the variance in the director's fees that were paid in 21 versus 20. And I would have thought that that would have been sort of a,
It should be year to year, but this was the year, at the beginning, because you had the election last year, you had, some board members that, swapped over, and a couple of those had prior,
okay,
fees of office, and so went ahead and got paid for those in this fiscal year, and since we booked those on that when it's paid basis,
okay,
that's why that number jumped.
okay, because that sort of threw me, okay.
Jenna and Chris submitted after the others.
Right, and, you know,
That's the difference.
okay. Okay. Okay, that was all I'll have so far.
Jimmy, may I make a comment? Sure. Number one, I truly enjoy working with you and Punja. You guys are true professionals, true professionals. I want to be sure to clarify for the public that's in attendance and those that may watch this recorded meeting that your audit does not look for the appropriateness of any spending by this board, just that all the money is accounted for. You're not hired to look for fraud, waste, or abuse of the public's funds. Is that correct?
Yes, in most scenarios, yes, that's correct.
After we talked on Friday, I sent you and Punja one example of what I consider fraudulent billing invoices regarding some letters. Did you receive that example?
We did.
Okay. Did you and Punja have an opportunity to discuss it?
We did discuss it, and anytime we get, so just to clarify, as far as our responsibility when it comes to fraud, as part of our initial, inquiries with the governing body, we do ask about any suspected or known fraud within the district during the fiscal year. And we use that information to essentially consider any adjustments to our normal procedures. And obviously, we do not look at every transaction, and a lot of transactions that we look at definitely at a much higher level. So the likelihood of us drilling down into a specific bill is very remote, because we're really looking at things like, all right, comparing budget expenditures to actual expenditures, comparing, say, the last 2 to 3 years of operating expenditures to the current year. More of an analytical approach on the expenditure side. So, but we did get your information.
And you got my governance inquiry as well.
Yes, ma'am.
And so it is a fair statement then to say that our bookkeeper, Michael Luft, is fantastic at his job. He makes our numbers work, right? He adds and subtracts very well. Everything balances out, and we are materially correct as far as our money is concerned for a $4.2 million budget. Is that correct?
Yes, ma'am. That's what
But
it is.
you did not look at any fraudulent activities. I don't want the public to think that because you are certifying this audit, that means everything is real clean in the books, because that's gaslighting, and it causes people to misunderstand what you're doing for
And
us.
so under our professional standards, we are, and we specifically call it out both in our initial letter to the board approving us for the audit engagement, that there could be transactions that are either incorrect or related to fraud that we wouldn't necessarily discover as part of our overall audit process.
And
Because-
if I bring them to you, you don't act on them, right? Because that's not what you were hired to do.
Well, we review the information that's provided to determine, does it change any of our procedures in relation to our audit performed under our professional standards? So it's not like we don't consider it, definitely don't, any information we're provided as part of the audit process, we definitely factor into our overall procedures as far as what we may or may not need to do. Now, it doesn't necessarily mean that we modify our procedures significantly based on, information, but we always wanna make sure we're aware of what's going on within a district, so that way we can plan our procedures accordingly to ultimately be able to conclude, on the overall, fairness of the financial information we're providing to the board.
I just wanted to make that really clear, because as you heard in one of our public comments, sometimes there's a misunderstanding that you dug deep in the books and you didn't find anything wrong, and that's not really the case. I just wanna make that real clear. Thank you.
Okay, Megan, did you, because you're on the audit committee, did you have any other comments that you wanted to make?
No, I don't. I spoke with them, had a good conversation with them, asked my questions.
Okay,
I don't have anything further.
okay. Okay, so right now, what we need to do is, well, Bill, tell me what we need to do next.
Well, we have one number to be confirmed, which is
Right.
the beautifications fund number, so we'd be looking for a motion to approve the audit and subject to insertion of that number.
Okay.
And the deadline for filing the audit is today.
Right.
So we're gonna be a little bit late no matter what. So I do recommend that the board consider a motion to that effect, approve the audit subject to that number being completed.
Okay.
It could also be subject to review by the audit committee if you like. I guess the number's gonna come from Michael. It's gonna go to the auditors, certainly the audit committee could look at it too. But then if we approve it tonight with that,
Condition?
condition, then we can get it filed this week.
Okay, well, I would like to move forward with that, so could somebody from the audit committee make a motion along that ilk? And then I would like to suggest that the final approval come from the audit committee. That once the numbers have been determined, that are gonna adjust those two highlighted numbers. Because the bottom number is not changing, it's just the grass in between, so to speak. Okay, Megan, Linda, one of you, as part of the audit committee, one of you wanna make a motion?
I'll make a motion that we accept the audit prepared by Maxwell Ritter. There you go, sorry, by that. With the modifications that are being made to the beautification fund and the amount of revenue that was collected in deed enforcement fines to fill that account.
so do we have any discussion? No more discussion? Okay, all those in favor say aye?
Aye.
Okay,
Thank you.
okay, you're welcome. Thank you very much for your service.
This microphone keeps moving by the way.
Okay, so now we're moving to the meaty part of our meeting. Agenda item number 3, interview of candidates responding to our RFQ. Okay. Who's?
You wanna do it again?
Yes, I'm gonna
Okay.
turn this portion over to Beth. Okay.
And then, Lloyd Gosling, would you like to come up first?
Sure.
Did I say your last name right?
Yeah, that's the name of our firm, yes.
Welcome,
firm
thank
name,
you
Beth?
very much for being here tonight.
Sure.
So I'm just gonna share with everybody, we're gonna do it kind of the way that we did it before, so, everybody will have time for, and we do need to keep a time on this. Catherine, will you be our timekeeper, and then also, Megan, do you wanna take the time when she's asking her questions? Are you okay with that? And then, so everybody is gonna be allowed to ask 2 questions each, but we do need to watch our time as well. So welcome,
Hi.
and if you wanna make a statement
Sure.
first, please do.
Sure, good evening, directors. My name is David Klein. I'm a partner at Lloyd Gosling, Rochelle and Townsend. This is my colleague, Maris Chambers. She's an attorney here with our firm. She and I have been working together on districts-related work and other matters in front of our regulatory agencies for over 5 years. I've been at the firm for over 15. Before I was there, I came from the TCQ, where I was the staff attorney there that was in charge of all district-related type matters with all the various things that would be filed, like bond applications, director appointments, surplus funds applications, things like that. And, we're excited. We know situations like this don't pop up every day, and we're really excited to have the opportunity to come talk to you and answer any questions you might have about whatever you want to know from us. Just one last thing to note, so I don't go on too long. I know lawyers can do that. Our experience, we've worked with districts of all shapes and sizes. Ones where maybe there are no landowners yet, ones that are growing, and then also ones where it's been fully built out. And we're not worried about issuing bonds to reimburse developers or anything like that. We're dealing with the homeowners that live here. And so we're experienced in that as well. But we're happy to answer any questions you have.
Thank you, we're excited to have you here.
Okay,
And just as a matter of professional courtesy, when we're done, we're happy to step out if you want us to step out whenever you're all done.
We record our meetings, so you can go home and watch it. So you may as well just stay for the end.
that's a good way of putting it. We're recording it anyway, so it's not like it's a secret thing.
Yeah.
Sure.
Yeah.
Okay, who would like to start?
I'll go first.
Yeah, go first, Linda.
In your experience with the Texas Water Code, are you aware of any statutory authority that allows the MUD to attach deed violation fines to water bills and then turn off water for failure to pay those deed violation fines?
Well, we're familiar with Texas Water Code, I think it's 49.273, and that's really the hook that gets a MUD the ability to, or any, districts that are subject to 49, the ability to tie in deed restriction enforcement with its other duties as a water district.
But I'm asking you if you are aware of any authority to put that fine on a water bill and turn off your water for failure to pay deed violation fines. Are you aware of any statutory authority?
I'm not.
You're not.
I'm not aware of any, but it's not to say, at the same time, I haven't ever encountered that situation.
None of your districts have ever done that? Do your districts that you currently support, do they, do deed enforcement?
Mhm.
They do?
Mhm.
How do they collect fines?
They do it separately through the letter writing case.
And then they give it to you? I mean, how do they collect? I guess.
They
what
work
I'm-
with just like y'all, work with the consultants of the district.
So they tie it to the water bill?
They don't tie it to the water bill, do they?
No, that's not my understanding.
Okay, they send a separate letter, you owe this fine,
Mhm.
remit the fine? Okay, so they're not attached to the water bill? Okay, that's what I wanted.
Sorry, I forgot.
All right.
Keep going, Linda.
Let's see, since I only get to ask you 2 questions, let me pick my next best question for you. How would you help board members understand the importance of enforcing contract terms, and what do you see as your role in enforcing those terms?
I think our job as your lawyer is to help keep y'all out of trouble. As board directors, you make the decisions, from a business perspective of how you wanna enter into a contract. Whether you think it's a good idea, whether you think it's a bad idea, whether it's something that is in the best, that you feel is in the best interests of the residents of the district. So if there's a contractual issue that arises, usually we are there to answer those questions and make sure we have well-researched and thought-out opinions on how you can go. Sometimes that's, I know, in public settings, that it's not, it's light, but sometimes you do it through executive sessions, and that's what the point of it is to have an opportunity to understand the ramifications of it, and that's the best opportunity to really work through those issues. Does that answer your question, Director?
It does,
Okay.
and since I only get two, I'll guess the rest.
Mark?
I have a question. As you heard earlier, we were accused of not being transparent. Okay, as you know, most boards are regulated, and it stipulates that everything the board does, any decision they make has to be in front of the public, at a public meeting, right? So if a committee, for example, the deed restriction committee, as they said earlier, decides to go and discuss an issue for a particular resident, comes back and presents it to the board, is that transparent in your eyes, legally?
Yes, I think so. When you have committees, the point of having committee is to usually have, for a district of five directors, you have one or two, so that there is no quorum, you have your meeting, but then ultimately, they can't make any decisions.
Right, they have to present it to the board.
It's the board, and a majority of the board is who makes the decision on that issue. And, you know, there's been a big emphasis at the legislature over the last several sessions about improving transparency, for water districts, whether it's through the bond issuance, their bond issuances and the information's included in those documents, or the increased level of information that needs to be provided on your website, which we took a look at. Maris and I looked at it, and we thought it looked good, and I think that's what the legislature wanted to see, and having information about your finances and directors' terms and things like that. And so I think it seems to us that the district is taking the right steps to be transparent, at least in the way that the legislature wants to see it.
So to follow up with that, now that we're in the age of, information, things are out there, things are recorded. In your eyes, let's say the board decides to take on a particular project, right? And a committee is formed, or one of the committees that's already formed goes and does all the legwork, and then comes back to the board, presents that to the board, and we're talking about expending funds, right? But they do it in a public setting. Is that transparency? In other words, we're not making any decisions at the committee level. We're bringing it to the board. We're gonna spend some money, a lot of money, but it comes before the board at a public meeting.
So yes, I mean, if committees can be really effective and good for the public and transparency, in the sense that you can have a committee meeting and not take up the time in an open meeting to vet 20 ideas and rule out the ones that aren't really maybe the good use of everyone's time to hear, because maybe they don't have any legs to them. But ultimately, you bring the set of best ideas, and you can deliberate those in a public forum, and everyone can be focused on what those options might be. We have a client that was looking to build an amenity center on land, and they had some land, and they were thinking about building an amenity center, and they were trying to think of all the different ways or other things they could do with the property. And then they created a subcommittee to help vet those things, and then ultimately, when it went to the board, they had a majority decision on what they wanted to do with the land. In a similar situation where there's a lot of landowners, there is an HOA as another layer that was interested, and so that's how they did it, and it went fairly smoothly. Yeah. Is that?
Yeah, I think so. I gotta pose it another way, but I'm thinking about it.
Okay.
Go ahead.
Well, I'll go first, but I just wanted to make a couple of comments. The first one was I'm really happy that we've got respondents from firms, because I think it's really important to have a deep bench in terms of, from a general counsel, because there's an awful lot of personalities that are in play here, and sometimes you need different personalities. And with that said, I'm interested in understanding how much research you've done about us. What do you know about us? Because there's a lot going on here, and whoever we pick is gonna be up to their ankles very quickly. And I have been, for the last 6 months, the proverbial boy with his finger in the dike, holding everything back, because I didn't wanna take on any new projects or new processes and have a general counsel change midterm. So for the, whoever picks up this contract, or, this process, is gonna have an awful lot thrown at them very quickly. And so, I'm gonna ask the question again, how much do you know about us?
Well, of course, I wouldn't be telling the truth if I said I knew everything that's going on.
Okay.
But I've spent some time watching some of the videos of past meetings.
Okay.
And I understand.
Okay.
Y'all have a lot on your plate, and you're dealing with a lot of issues, whether it be the wall, or what you're doing with the pond site, or what may be the appearances of what's going on with the pond site, but not necessarily what's going on with the pond site. We understand that deed restriction enforcement is something that is a hot button issue with your constituents, with you, and having to deal with it. And we're still here. We're still interested.
Okay.
You need, it is clear to us that you need someone, you need a group of lawyers that, have the skill set to represent the district right. You need some that are going to be attentive and have the bandwidth to be able to help. And Maris and I have the bandwidth, but if we don't, in a moment, we do have a deep bench. And we have, over 13 dozen lawyers, water lawyers of the state in our firm, so that if we need some extra help, we can find them.
And I can plug our paralegal, he's amazing, so.
Fred Castro was the original paralegal, I believe, for this district.
Yeah.
Like how long ago?
30-ish years ago.
And, so you still have him, is what you're saying?
Yes.
Oh, okay.
Well, actually, he was at the law firm that created this district.
Okay.
So we stole him.
Exactly.
Yes.
Okay, so what is, so I'm gonna ask again, what is your experience working with boards that are in chaos? That's the C word I chose. There could have been other words that I chose, but that's what I chose, in chaos.
Well, I have plenty of war stories I could share. Not every district's boards votes 5-0 on every issue, right? I mean, everyone has different opinions and different takes on things, and certain projects are more important to others. I think what's important for what you need from your general counsel is to be a good listener, hear what everyone has to say, and just make sure that whichever way the district wants to move forward, that you're not making a misstep legally and getting yourself in pickles.
Keep us out of trouble.
Pickles is a legal term I like to use, but yes.
Okay. Megan, you wanna go? Yeah.
Sure, I can go. Yeah, thank you so much for allowing me, really appreciate it. So, I have another deed restriction related question. So as you may or may not know, we are a district that enforces deed restrictions, and well over half of our residential properties are not represented by a homeowners association. So it's kind of a challenging position for our board to enforce rules that it doesn't have the authority to amend at all. So in the absence of an HOA for so many of our properties, this board is in an important leadership position with regards to helping our residents understand their deed restrictions, the nuances that govern their enforcement, and, possibly most importantly, as our neighborhoods mature and evolve, the process that residents would need to go through in order to amend their deed restrictions. So, my question is, as general counsel to the district, how can you help our board engage in a more intentional and open public conversation about deed restrictions, recognizing that there's this boundary between, providing legal advice to the district and not to residents, but how can you help us have that conversation with residents?
Yeah, I think, again, like you said, you have to understand what your legal parameters are. How far can you go, before you're crossing the line? Because you don't wanna get in a situation where or you need to know where the line is, so that if you do just, if you decide from a business perspective to go across a line, that if all of a sudden, there's negative ramifications, your eyes are wide open to that situation. And so to that point, what we usually find in anything, regardless of whether it's deed restrictions or just any topic, if you have an open forum to talk about those things, and that includes your other consultants that have their experiences as well as what they're seeing from putting in these deed restrictions and the effect, the impact, that usually helps at least mitigate some of the tension and difficulty that comes with it, with all the conversations of enforcing it.
Okay, so my second question, I noticed while I was looking at your firm's website, you have a podcast, which I appreciate. So I listened to a little bit of it, and one of the episodes that I listened to was Ethics and Leadership in Challenging Times. And so one question that came out of that for me when I listened to that was, how do you define and identify behavior from an elected official that results in unjustified harm to others? And I'm not talking about physical harm, because that's pretty easy, but other types of harm. And what checks exist within the law to ensure that that type of behavior isn't tolerated?
That's an interesting question.
Yeah.
Because I did not give that podcast.
I know.
They're banging on me to give one on districts and CCN issues, but we just haven't gotten around to it. But that is a really important topic. What can you do? I think that, again, I don't know if it's necessarily a legal issue. It's one of these things that if you could have conversations offline, so that there can be an understanding of the different goals that officials may have. It maybe helps to have a better awareness. And maybe if there's a little more awareness of each other, there can be more listening, and then perhaps I want to say robust, but a good, a thoughtful conversation about the topics. I understand you're saying there's challenges, and maybe you don't have 5-0 votes on things, but just having the opportunity to talk these things through, maybe through the committees, is a way to do it.
And setting up just general rules of order about, how you speak with each other, which I can very much
Sure.
see that you have in place already. But as you already mentioned, it's our job to keep you within the lines of the law. So, that includes, doing the best we can to make sure those ethics rules are followed as well.
Can we take a quick pause? The system's showing an error, it doesn't show that it's not recording, we wanna stop it and start it, to see if the error clears.
Okay, that's fine.
It's the scrambler.
Yeah.
Can I ask how you found our RFQ, or did I invite you?
No, a colleague at our firm found it, that knows this area. So,
Well, I was sending out random emails to law firms that handle water districts, and so I wasn't sure if I had sent one to you, or
I sent it to them.
you did.
Okay, yeah, I was wondering, like, where were you in
I
December?
sent it to
I
them.
sent it to them in December for sure, because they're on my list. I did send it to your website.
Oh, I mean, maybe someone that might, but,
We're glad you're here.
okay.
Yes.
So it didn't go to our email.
Yeah.
No, not any, no, just your general, you know, everybody sends to your, you know, it's the side trash can.
I've done it twice. It goes into error mode immediately. I don't know beyond that why it's doing it.
Is it, can you look on and see if it's actually recording?
It's not, but I looked at it.
It's not.
The-
David, is your phone recording? David?
It is, she knows the answer.
I can't tell you if it's recording voice only. I can tell you that the error is showing it's not picking up the picture. Beyond that, I don't
Okay,
know.
well, they can't see it, so that's okay. We've got it recorded over here. That'll work. I guess that's good.
Mackenzie, can you text me?
I'll take it out and see.
It's recording still.
Yes, we got that one.
And I was like, oh, I'll see if I can see it. It's like, well, when you're in airplane mode, that's not gonna work. Okay,
Wanna keep going?
yeah, keep going, yeah. There's nothing
Okay.
else that we can do, it's just, you know.
So I have the last two, so,
Can we just, can I just supplement a little bit?
Sure,
You know,
absolutely.
Mayor makes an excellent point, and with, it's not to say, I don't know if you have them, I would think you do, but,
Have what?
there's a lot of districts out there that in addition to, your general policies, you have an ethics, your own ethics policy, right, and your rules. I mean, it's only this big, but it's this thick, I got Robert's Rules of Order, right, but, that's really a last that's something you never wanna have to like, say, hey, look at this, let's just try to figure it out. I like to keep it in my
yes.
I do
Thank
believe
you.
chapter 49 requires an ethics policy too, so.
We do have one.
Okay, my two questions is, the first one is, what can you tell me about the new legislative laws regarding residents' privacy?
Where was there about 5 bills that came out of the 2021 legislative session that dealt with, or at least that we were implementing with our other districts. I think about 2 or 3 of them dealt with either making sure that additional information that needs to be kept on the website, information that needs to make sure that it's not disclosed, that if you have someone else that's doing your water bills for you, there's wastewater bills, there's information that needs to make sure that if they get hit with a Public Information Act request, that they protect certain information.
And that notice needs to be on the bill too, so that people are aware.
And I think there was that's the third one. I think it's also
Okay, thank you. Are you familiar with Bill Milburn's community CRs?
Not directly, but I know of them. And I know that he's built a lot of different communities across the city. I live in one over off of Far West. I live on Balburn, which my understanding is Mr. Milburn's daughter Valerie, that's how they came up with that street name. But do I have active, can I speak to what his model CRs look like? But there's a lot of things we don't know, and we pick them up pretty quick.
Okay, well, thank you very much. Mr. Evans?
Yes, ma'am.
Come up.
Evening, everybody. Brought my homework with me as instructed.
What are you bringing?
Well, exciting stuff, I promise.
Thank you.
Yes, ma'am. Good evening, directors, Madam President, it's a pleasure to be here again. The paperwork I gave you just now is in response to an email I got from Ms. Nix, and she's indicated y'all will be looking for a proposed, engagement letter for whoever you select tonight, as well as any, necessary waivers. And so as we discussed last time, we did have potential, conflict, with Sage Management. And so there is in that packet a 2-page waiver. If y'all decide to engage with McGinnis, we would ask you to, execute that waiver along with, Sage Management. So that's what's in that little packet I gave you. I'm happy to resume our conversation from last month. I'll, do my best to answer the questions.
I'd like to ask for a little leeway here. So just so I'm clear, so we're all clear, what exactly is your waiver? What does that mean?
Right, so the waiver would be, again, as we discussed, so McGinnis Lockridge was engaged by Sage Management when y'all were negotiating the services agreement that they have with y'all to provide deed restriction enforcement services. And so, at that point, we did that work for Sage. Once they completed, or I should say y'all, once y'all executed that agreement, our representation of Sage on that matter concluded. However, because we did previously provide legal services to them, there is a conflict of the professional rules of conduct, which require us to get a waiver from 2 clients if we do have a conflict between those 2 would-be clients. Obviously, our prospective clients, whereas Sage is a former client, but the duty persists nonetheless. So, again, this would be a waiver that we would have to have it executed by you and Sage if y'all were to engage McGinnis Lockridge. As far as I know, Sage has not raised any concerns about it. Obviously, y'all have, if it's completely within your purview, to ask me questions about it. If you got concerns, any of the above, that's what we're here for. And I think we did touch on this last time. If for some reason, you'll need to renegotiate that contract, I would recuse myself from representing the district on that matter. So I realize that is, a complication for you, but if, you consent to it and Sage consents to it, I can represent one of you on that if you want, but I would, as a preliminary matter, recuse myself up from that unless and until y'all direct me otherwise and Sage concurs. Does that make sense?
Yes. Okay. And I'll start this time just so we go backwards, because I'm sure what I just asked is, someone asked you just the exact same question.
Okay, that's fine.
So what can you tell me about the new legislative laws regarding residence privacy?
Yeah, so, the one that comes foremost to my mind, is the amendment to chapter 182 of the Utilities Code, where, previously, I think it's 182.152, don't quote me on that subchapter. But previously it required, in order to, preserve your personal information, that's information relating to your home address, your billing information, account numbers, things of that nature. It used to be that in order to protect that information, you had to submit an opt-out request. I'm sorry, I just keep knocking this over, so I'm gonna set it over here and stand here. It used to be that you had to opt out from the utilities authority to issue that information if it was requested under, say, for example, a Public Information Act request. But the legislature omitted that to where it's an opt-in now. So, if you want your information, personal information, to be made available to individuals under the Public Information Act, you have to actually go down to your utility provider and opt in to releasing that information. I haven't encountered anybody who's opting in to have their personal information released, but that's how the legislature drafted that. That's the biggest one that comes to my mind. I freely confess, I do not have a working mental Rolodex of all the legislation in the past, but that was by far the most attention-worthy one that I picked up on.
Okay, thank you.
Yes, ma'am.
The second one is, are you familiar with Bill Burns? I don't know why I can't say his last name today.
Yeah, just from, we represent Anderson Mill, Limited District, we've got the ranch as well, Fern Bluff, I don't know if Fern Bluff was one of these communities or not, but I've seen that name on covenants and restrictions quite a bit.
Okay.
They do kind of tend to follow, the same patterns and whatnot. I haven't seen one that looked like it was drafted in the last 2 decades, so you're probably, I'm guessing you're probably working off the same era of deed restrictions that those other districts are.
Okay, thank you.
Yes, ma'am.
Thanks for coming back.
Yes, ma'am.
Hanging with us. I'm wondering if you could answer the same question about the deed restriction that I asked. I don't know if you want me to repeat it or repeat a shorter version of it.
Sure, if you want to
Shorter
repeat
version of it.
yeah, just.
Your shorter version of it. Yeah, how can you help our board be in a better position to have a open dialogue
I got
with?
you, I got you. So, it's a difficult one. I think I told y'all this when we visited last time, that, if I didn't say it, I was thinking it. But I'm not aware of, any districts, in this particular area. Certainly none of the districts I represent have an entire night set aside for deed restriction related issues. And I'm not saying that's a bad thing at all. To the contrary, when you've got, I think, a fair number of people who have concerns about your deed restriction enforcement, policies and procedures, I think, erring on the side of caution, having this open forum is very, very important. So you're doing that, but it seems to me, again, this is just me kind of peeking inside, from the outside, and I will repeat what I told you last time, I've gone out of my way to not watch your videos. I've seen precious few minutes of them where I thought it was necessary, but I've done my best to not draw any prejudices or preformed notions of who you are as directors or who you are as individuals. So I just want to put that out there. That said, your DRC meetings, from what I can tell, kind of seem to have turned into, Friday Night Lights, for lack of, a better term. Public meetings, are just that, obviously, everybody's got a right to attend, but what you're doing in the meetings is a totally different question. And in my mind, if you're not coming down, being productive, getting things done, then the meeting is a waste of time, it's a waste of money. You've got consultants here, you've got lawyers racking up bills, and so I don't have a great answer to your question, but I do think it's important that you sit down and figure out what it is exactly we're doing. If we're having 2 meetings a month, they can be 2 productive meetings. I preach this all the time whenever I have districts that get bogged down, and before we know it, we're talking about deed restriction enforcement, and before we know it, we've kind of disintegrated into kind of petty jabs and comments and whatnot, and that comes and goes from the board and from the audience. I've seen it. And so, it's important, one, that when you're holding a meeting, you're getting stuff done, you're not dwelling, you're not digressing. Also, though, that, we talked about this last time, if y'all engage with me again, I will expect y'all to adopt rules of decorum and procedure that you follow. I don't care what the rules say, by and large, as long as they're not discriminatory towards your constituents. I don't care what they say, but I want you to adopt and follow rules of procedure that will keep you in line, that will keep you, from digressing and going down rabbit holes unnecessarily. But again, if you don't follow your own rules, they won't help anybody. So rules, keeping, your eye on the prize, so to speak, as to what we're supposed to be doing here, I think it's very, very important. And, as contrary as it may sound, to want to limit, conversation in an open meeting, sometimes it's what you gotta do to move on and get to the next issue of business before you. So I'm not sure that's a great answer, but I think there's a lot of things you're gonna have to do, to really get this process under control, from a time standpoint, and a management standpoint, but also, to where you don't have constituents, who are afraid that they've got a governing body up here doing nefarious things. I don't have any reason, I haven't worked for you, so I'm not privy to peeking behind the curtain, but I do know that you've got constituents who are upset and concerned. And I know that before I even walked in this room, I knew that when I was at my other district, one down the road. So, the fact that I hear WTC MUD #1 and other districts, it's telling. It's telling. And so I think y'all can do better, and I think we can help you do better.
Thank you.
Yes, ma'am.
You have any other questions?
Yeah, I can ask one more. I wanted to read just a section from your cover letter, if I could. You said, "To to be clear, we are of the opinion that board meetings are meant to be productive, civilized, and conducive to public participation. We will not participate in any meeting where one or more directors intentionally interrupts others, belittles or insults other directors or members of the public, or attempts to prevent the board from carrying out its duties to the district. Texas law, even without the board adopting rules, provides adequate means for addressing and minimizing interruptions of public meetings, whether by directors or other attendees. We will ensure the board knows how to utilize such laws and will expect a majority vote from the board to remove anyone who is disrupting a meeting. You touched on this a little bit in your last answer, but I'm wondering if you can expound on that a little bit. Talk about why that's important for open meetings, why it's important for transparency, why it's important for having a government where public participation is encouraged, and also how what you said there extends to behavior outside of our board meetings.
Sure. I used to appear before a judge when I was prosecuting, one judge in particular, and she used to always tell defendants who hadn't been there before, you're entitled to your day in court, but not all day. And you know, I say that somewhat in jest, but it applies here too. Again, having open lines of communication with your constituents is important. It's important, and it's a statutorily required mandate that you listen to constituents when they come up here and speak. But it doesn't mean that you have a free-for-all, and it doesn't mean that you have to engage in a back and forth. And to the contrary, I think y'all know that citizen communication is not really supposed to be a back and forth unless you've got an appropriate agenda item on it. You know, if it's me and I'm in your shoes, I listen intently, make myself mental notes if it's something I need to follow up on it, and we move on to the next agenda item. Okay, so, and that's kind of where we come to rules of decorum. And so the way you interact with each other up here is just as important as, you know, how the audience interacts with you. So if you have, for example, you know, Director Evans has had a bad day at work and he wants to come up here and take it out on everybody and is being disruptive, cutting people off, being rude, whatever it may be, that's the chair's opportunity to correct that behavior and inform Mr. Evans he has one opportunity to correct that behavior, or else he will be asked to leave. And if Mr. Evans doesn't correct his behavior, that's the opportunity for the chair to have that person removed from the meeting. Now, if it's the chair who's being disruptive, that's the opportunity for three of you to say, Madam Chair, you're being disruptive. We're here to do work. Please correct yourself. You understand where I'm going here? So at the end of the day, the chair, the board president, who you all elected, should be the face and the person running your meetings. That's why you elected her to be your board president. But that doesn't mean that the president is infallible either. As far as audience interruptions are concerned, you know, knock on wood, I haven't seen a whole lot of that in districts. I will tell you where I saw a whole heck of a lot of it, and that's when I was representing cities. You know, you got a lot of angry people upset about a lot of different things, and so, you know, whether you think so or not, you don't have it that bad. It might feel like you're banging your heads against the wall, but I promise you it can always be worse, and I've seen worse. I've seen people hogtied and dragged out of city council meetings. I've seen a lot of crazy things. But to that point, Texas Penal Code does very clearly state that a person who disrupts a public meeting can be removed from that meeting, and is a Class B misdemeanor to intentionally disrupt a meeting, whether by physical act or verbal utterance. So, to my point there in the letter, you know, I can give you the tools, you know, I can tell you what the law is, but at the end of the day, if you choose not to exercise them, that's on you.
Okay.
Does that answer the question?
Yeah, I don't know if you had anything to say about how some of this, it extends to between meetings.
I'm sorry, you asked about outside meetings. You know, that's probably even more difficult to address because, you know, everybody in here, to my knowledge, is an adult. You know, we all drive up and down the same roads, we all breathe the same air, we sit in the same traffic, we all pay the same taxes that we all hate. Most of us have an HOA and deed restrictions that we've got to deal with. I don't care if you're on that side, this side, inside, outside, it doesn't matter. We're all dealing with the same stuff. So, you know, me shaking my finger at you, is it going to, you know, alleviate any long-standing hardship that you've had or any deep-seated disagreements that you might have had with a neighbor, but you have to stop, take an assessment of what you're doing, and I think your constituents do that too. I hope they do. I hope everybody's doing that, and asking themselves, what is it that we're trying to do here? Are we here because we have a legitimate concern about the way the board's conducting themselves? Or are we here because, wrestling's not on tonight? So how you go home, how you conduct yourselves on your walk home, that's a hard thing. It's a hard thing. If you've got, directors who are going out of their way to make other directors' lives difficult, that's a problem. How deep seated that problem is, I don't know. It depends on the circumstances and the facts presented. But again, as with the rules that I was discussing, if you choose not to act like a considerate human on the way home, there's not anything I can do about that. So, I wish I had a great answer for you on how to fix people's misunderstandings and disagreements with one another, but, I will say that I think there's a very common misperception amongst folks who don't work in government about what government's really doing at this level. Okay, I'm talking about your most basic local layer of government. I mean, we're smaller than cities, and we should be more responsive than cities, and we are most of the time. I guarantee you pick up the phone and you get a hold of somebody at a district I represent, it's gonna be a lot easier to get somebody on the phone in the city of Austin or the city of Dallas or whatever. So, I think we need to keep focus of what we're doing here. If you've got, a bitter feud with your neighbor or whoever it may be, there's not much I can do about that, but I encourage people to stop, take a breath, and think about what we're doing here. I think there's this misconception that government, is this partial party politic machine that's gotta go, and no matter what level of government you're in, you gotta be caught up in the stuff that you see on TV every night. I assert that is complete, total horse hockey. Okay, that's not what we're doing here. That's not what we're doing here. There's a reason there's no D or R next to your names when you run. Okay, you're here to provide water, wastewater services, law enforcement, solid waste services, and parks. Deer restriction enforcement, you've got that authority. The legislature gave that authority. Whether you choose to participate in that activity is a decision for you to decide. You are doing that, so I presume you want to continue doing that. But I will do my best to try to help you do that in a way that's not dividing and it doesn't feel like people are getting picked on. Because I know when I've gotten taxigrams from my HOA, I always feel picked on. I'm like, they get off telling me my stereo's too loud, Black Alley, we're all humans, right? So, I'm sorry, I'm digressing here, but the things you're dealing with here in your district, while not unique, that they can be fixed, and I think, that has to come from inside on a lot of levels. Sorry for that meandering answer.
Okay.
I'll get off my soapbox there.
Okay, I'll jump in. So I would like to, and first I'd like to say, Megan, thank you for reading that, because I had that on my list of things too. But one of the things I wanted to do, was to expand, to ask for some more context so we will ensure the board knows how to utilize such laws and will expect a majority vote from the board to remove anyone who's disrupting the meeting. So, I'm just checking for clarification. So if we have, a member of the public who is being disruptive, you're saying that the board has got to have a vote, that we can't just have the constable take that person out of the meeting? Is that your record, your legal,
I wouldn't even go that far, honestly.
Okay.
Again, you as chair, you have a right to enforce rules of decorum, as well as the law within your meetings. Now, the only reason I can see that it should boil down to majority votes to remove somebody is, like I said, in the facility example, where it is another board member or the presiding chair.
Okay.
I don't think that's actually a scenario I don't think I've seen where the chair was the one being unruly, but I'm not saying it can't happen either. But my frustration, the rare occasions I get into a meeting and I really want to pull my hair out, it's where things have ground to a halt and we're not doing anything productive except for loading screen, that's not productive, honestly, you know, and so, a lot of times that's because of this back and forth you get into with an audience, and that's not why we're here. If you want to, take citizen comments in between, before and after every agenda item, that's your prerogative, great. If you want to adopt rules like that, great, that's fine. It will make your meetings longer, but that's your prerogative. But once that time period has closed, that's the time for the audience to be quiet, so you can do your business. And so, if you've got situations where there's an audience member, or a consultant, or another director who is, the reason you ground to a halt, that's what I was trying to get to in that letter. You know, I want you to take the tools that we've given you and the law that the legislature has adopted and put at your disposal. I will hope that you exercise and utilize those to keep your meetings moving.
Okay, I don't have any more questions. I guess your next art, okay, yeah.
I wanted to ask a question here on page 2. You said we try to manage our business efficiently in order to deliver legal services in a cost-effective manner. That would require some outsourcing of some functions, you know. How deep is your law firm as far as representing us? We're a small district, but as you know, we have a lot of issues with open records. Deed restrictions is a big one, you know, records retention, all those issues that come up and require a lot of legal services. So can you describe your span of work and how you would meet our requirements?
Absolutely, sure. So, you know, I myself, I'd say 90% of my work is with districts and water supply corporations. We've got about 15 that the firm represents around the state, most of them are in central Texas, but that is the meat and potatoes of my work. Coming to these meetings, doing the day-to-day general counsel work, that's primarily what I do. I do some work before the Public Utility Commission. I've actually worked with Mr. Klein on a couple of items, not too distant past, but I'm not over there a whole heck of a lot. But we do have a very robust land and water practice group at McGinnis-Lockridge. We've got attorneys of varying degrees of experience from 50 years to 3 years practicing in land and water matters. We've represented, in addition to the districts that I work with on a regular basis, we've also represented cities as general counsel, also one-off type of representation such as litigation, rate cases, water, wastewater rate cases, things of that nature. And we also have an electric practice group that works with cities on electric co-op type matters. But outside of the water and land and water practice group, we have a corporate practice group. We've got a full litigation section, and we've got deeds and estate, deed and trust, excuse me, estate and trust, excuse me, and oil and gas. I suspect you are not going to have any oil and gas issues pop up, but suffice it to say, we have a great team. I think the firm, we're at about 70 attorneys right now statewide. Most of those are here in Austin. We've got offices in Houston and Dallas as well. But we do consider ourselves a one-stop shop for our clients. I'm trying to think off the top of my head, anything we've had to source out lately as far as legal services are concerned, and I can't think of a thing. We handle the Public Information Act PIRs that come in for our other districts, of course, districts and water supply corporations. Suzanne McCullough, my paralegal, who I mentioned last month, my paralegal in right hand, she's here. She's been working with districts for going on a decade, give or two, is that right?
Yeah.
Yep, about a decade. So we're very well versed in the Public Information Act, the Local Records Retention Act. We've got it down to darn near a science. I say that when I came in here last month, I told you the law is not a science, but the PIR stuff, you've got it down.
But you do outsource some things, right,
For legal, we haven't had to. I'm trying to think, bond counsel, or we don't do bond counsel. I don't expect y'all to be issuing bonds anytime soon, but, can you think of anything, Suzanne, that we've sourced out lately? Yeah, I I can't think of a single legal issue we've had to source out. And to be fair, what you've got in front of you, honestly, I tried to revise, every, engagement letter to fit the client, but there's also some boilerplate language that we can put in there just, out of due diligence, and I don't think there's many attorneys out there whose engagement letters don't have some level of boilerplate language to them, just as proverbial CYA for the lawyers.
Understood? Yeah. Okay, thank you.
Yes, sir.
Linda?
The contract that you, negotiated for Sage Management that they operate under here, what role could you play in the enforcement of that contract, or would your involvement in the contract dispute with them be a conflict of interest?
Yeah, well, again, that kind of boils down to, their level of comfort and yours as far as, renegotiating that contract's concerned, should it become necessary. If this board's not comfortable with it, then I will recuse myself, like I said, and you will have to find another attorney to negotiate that with you, if you want.
I think I've either misstated the question, or
Okay, I'm
maybe you
sorry.
didn't catch it. If there is an issue with their, observing their contract terms, are you,
Oh,
would
I
it be
see
a
what you
conflict of
mean.
interest
I
for
see.
you to correct that?
I don't think so. You're talking about breach of contract versus negotiating a contract, and I see those as two very different things.
So if it was a breach of contract situation, because you wrote the contract, how could you deal with that?
Well, I mean, breach is breach. I mean, if somebody doesn't pay, they don't pay. If somebody doesn't provide a service, they don't provide a service. I think there's a difference between negotiating a contract and enforcing it.
Well, okay, but I don't know those differences, but you could handle the breach part?
I feel so, yeah, absolutely.
That would not be a conflict, even though you wrote the contract.
No, I do not feel it would be.
Good to know.
But again, I want to make this very, very clear. This is your decision to make and Sage Management's. So if we got to that situation, okay, we're talking about a breach issue. If y'all didn't feel comfortable, with me going to work on that, I step back regardless. So you hold the cards.
And then we would have to hire another lawyer to
Yes, you
handle
would.
that
Yes, you would.
situation?
Yes, ma'am.
Yeah.
Assuming you want an attorney to do that, I presume you would.
All right, that's for that one. In your prior interview, when I asked you about deed violation fines being applied to water bills and water services being terminated for failure to pay those fines, you stated that the water code did not give the MUD statutory authority to do so. As an attorney and a sworn officer of the court, what actions would you take to address the acts, rules, and resolutions past or pending that do not conform to statutes?
Yeah, a lot of that falls back into the, you gotta follow your own rules category, I don't know which resolution specifically you might be talking about, but a lot of those, there's not much teeth in them. And if anybody sits up here and tells you that every resolution y'all adopt, it carries the force of law, and by golly, we'll march into a courtroom and I'll get myself an injunction and you will follow this resolution. No, it's not happening, okay?
Have you looked at our resolution?
Oh heavens no. Man, listen, just the fact that I'm standing here right now is a high accomplishment. No ma'am, I have not.
Is that in general, a resolution can't stand up in a court of law?
No, that's not what I'm saying. I'm just saying that there's a lot of stuff that districts adopt that just does not have any teeth to it. And so, again, I'm just gonna go back to the rules of decorum, example, because it's the easiest one most pertinent right now. But, I would have you adopt a resolution that, commemorates your adoption of those rules. We'll have some nice little recitals in there saying this is why we embarked on this mission, and you're gonna have your boilerplate language at the end that repeals conflicting resolutions or provisions that y'all adopted elsewhere. We'll have an effective date, things like that. But at the end of the day, if President Frankie decides that she don't wanna follow the rules, the judge is not gonna come down here and, start kicking down doors. So that's why I'm trying to say, not all these resolutions just have a whole heck of a lot of teeth behind them. So if you're talking about something a little bit more substantive perhaps, can you give me, how about this, can you give me a good example? And maybe I can, maybe that'll help.
Well, actually, what I'm trying to get you to tell me is, if in fact it is not within the MUD's authority put violation fines on a water bill and turn a person's water off.
What am I gonna do to
pay
stop
those-
that?
What are we
Gotcha.
gonna do to stop that?
Gotcha. This, again, y'all are the playground monitors. I can help you, but I can't have you, I can't make those decisions for you. So I will tell you, and I absolutely stand behind my answer, there's nothing in the water code, chapter 49 or elsewhere, that it says a district can put fines for a deed restriction violation on your water bill. As we talked about though, there are a ton of gray areas in this practice. I mean that in local government law, district law, especially, there are a ton of gray areas that you operate in. I know you will not find this in statute, but generally speaking, I look at districts much like I would a general law city, and that you only have the powers that the legislature specifically grants you. Okay, it's the same for general law cities, I mean, cities underneath 5,000. They only have the authority that the legislature provides them. That is as compared to a home law city, for example, City of Austin, Cedar Park, Round Rock. These are home law cities, home rule cities, excuse me. And rather than being limited by the legislature and the powers that are granted to them by the legislature, they can do anything that's not prohibited. Y'all are not a home rule city. You are more akin to a general law city. And so, again, you're not gonna find that written in statute anywhere, but you have to look at the law and the laws that are written around it. Take for example, cities. If we're talking about cities collecting utility bills, there's there's I think 2 AG opinions, and they're quite old, but they have not been rescinded or otherwise overruled by courts or statute. But the AG was asked to evaluate 2 circumstances where cities took it upon themselves to put a fee on their water bills, their constituents' water bills. One, I think, was to fund police projects or something like that, and I don't remember what the other one was, but suffice to say, it had nothing to do with water. And the Attorney General came back and said, no, you can't do this, show me in statute where it says it's okay, So, the point being is, even though, to Mr. Klein's point, chapter 54, even though it does say a district may take all actions necessary to enforce deed restrictions, you still have to, and I think if a court got down to looking at this question, I think a court would go back and look at the statute around the collection and imposition of water and wastewater rates on bills, and they would look at the utility code, they'd probably look at chapter 552, local government code that regulates largely how city-run utilities operate. They look at all this stuff as a whole. And so, again, looking at those, there's not really a situation in any of those where you can take this completely unrelated issue and use it as an excuse to cut off somebody's water. The utility code lays out some really specific instances of why you can or can't cut off somebody's water. And I think the legislature wanted to give that right to districts. They would have said so.
So is your position, are you telling me that your position is, although you would advise against it, as you told us last time, you would advise not doing that? If 4 members of this board decided that was a better idea to do it anyways, then you would just let that go?
Well, again, you're not breaking a law by doing that, because there's no law to break, right?
Well,
Now, there's a very big difference though between that, operating in this gray area, which
Yeah.
y'all have been.
Yeah.
I mean, get a lawyer up here, there's 2, 3 behind me, and if they tell me that's not a gray area, I'll go ahead and exit the room and go home. But it is a gray area. We operate in them all the time. So if you're asking me if I'm gonna go up to the DA's office and say, WTC MUD number 1's board is putting, deed restriction fines on people's water bills, no, I'm not gonna do that. Y'all are grown-ups, okay? That's all. I don't know how many different ways I can say it, but you have to regulate yourselves, you have to be practical, and you have to listen to advice. You don't have to. You don't have to listen to the advice of your legal counsel. People disregard it all the time. But that's why we're here. That's why, you and the rest of your constituents are paying for lawyers to be here, is to keep you out of trouble, just like Mr. Klein said.
I think that's what Liz is trying to get to. Is it illegal to do that?
Right, well, that's the thing.
It's a gray area.
It is, I mean,
So-
I
so
don't
would
have a better
okay,
answer for you.
Would it be fair to say that in a gray area, you err on the side of caution?
I absolutely do, and that's why my advice to you would be do not do that.
Okay. You have answered my question.
Sorry it took me so long to get there, but I was trying.
It was worth
There
it.
you go.
Okay,
Okay.
I promise it'll never be boring, Mel, it'll never be boring.
Okay, so, I guess that's the end of the interview process. Okay, thank you very much.
I just wanna add one final thing, I'm not counting chickens here whatsoever, but I do note, of course, you all have several other items on the agenda with respect to, engaging, new general counsel as far as and as well as terminating, your present, services. If y'all do take a vote and your vote is to hire McGinnis, I can tell you, we are obligated Wednesday night, so we will not be able to jump on the clock and be at your meeting Wednesday night, but we'd be willing and able to take over, and transition going into March, so just wanted to
Okay.
have that information.
So just to clarify, it's like, you got plans Wednesday, okay? But not next month?
No, ma'am.
Okay, okay.
Yeah,
That's fine.
by the time we found out we had to come back, we were already obligated for Wednesday night.
Okay.
But most of the time, Mondays and Wednesdays are open.
Thank you so much for
Yes, ma'am.
Yeah, thank you.
You should stay and listen how it turns out.
Oh, I am.
Okay, agenda, item 4, selection of a new general counsel. Okay. Somebody start off talking.
Who did their, criteria scoring? Who scored? Anybody?
I've looked at it, I've gone over it more than once. I
Did you-
looked at it a
did
month
you do
ago
this
and
one?
one month.
Okay, well, so that you know, and it was in the RFP, you guys fill out your stuff, we score you, that's how it is. Did you do it?
No, I didn't do
Did
it.
you do it?
I didn't write it, I did it though.
Oh, you did it. Do you have it with you?
No, I didn't write it.
Oh,
I just did it. I went through it.
Okay, well,
I
so
didn't
I'll
print it.
start then, Catherine, I'll
Okay.
start. I went through and was as objective and as fair as possible, and Zach did answer one question that I could not find in his document, so if I was gonna put all that in there. And here is my perception of what I've seen. Both law firms and both lawyers are excellent, that's hands down without a doubt. But I think that David Klein has, 15 years of experience in the business, and his, Maris has 4, where Zach has, I got 10 as a lawyer, but I couldn't tell how many in a water
Doing
district.
water work, this is my 4th year.
Okay, so the length of experience definitely goes to Mr. Klein. The proposed legal personnel, I'd say neck and neck, the firms, now that Zach has told us more details about his, I'd say size-wise, they're probably neck and neck. Neither one of them discussed a transition plan. Qualifications based on Appendix 2. Zach didn't respond to Appendix 2, but I took your last interview and everything you wrote in your cover and gave you points anyways. For that, what I could glean. Mr. Klein did take the time to fill it out, so it's a 20 to 5. Reference check, that I wanna scratch if we could, because the way it was written in the RFQ was give us references for municipal cities. We didn't do water codes, so Mr. Klein gave us cities.
No.
And so I don't think it's a fair ask. So if you scratch them both, nobody gets any points for that. Resource capacity, now that we know that's a neck and neck thing, now that we know the size of his firm. Basically, in my opinion, Mr. Klein has more experience in water district business than Mr. Evans. And so my scoring, Mr. Klein got, or that law firm got 70 and McGinnis got 20. So by the scoring criteria, hands down, the other law firm for better. Both good law firms.
Yeah, I agree,
But one has an infinite number of more years of experience, and with the kind of chaos you're describing, I think that experience would go a long way to resolve.
See, I saw a little bit different where I think with the legislative laws and with Bill Milburn's community CRs, I see that more on, Zach Evans' firm, that because he's been doing that for the past so many years, and he's been doing that in other districts that are not far from us, that's what he does daily.
He doesn't do legislative matters daily, and he
No,
doesn't do
he's
deed
working with,
enforcement.
very close and similar to Bill Milburn's, practices, what he's got. So those are some of the things that I've seen.
I didn't catch that from his interview, Beth, but, Milburn's, deeds,
are horrible.
they're horrible.
They're horrible.
They're
And he has experience with
Yeah,
that,
and
so I'm saying
hands down,
a lot
they're
of
horrible.
Well, but our business isn't deed, our primary business isn't deed enforcement.
Well, with deed restrictions, it's a big thing that we need that. So, I'm just saying, I'm
Okay.
giving my opinion.
Okay,
Yeah.
so
Who
Megan,
was stronger in their opinion, the deed restriction?
There was no real question about it, other than did you have knowledge, and they both were neck and neck even, because they both said that they have districts that they do deed enforcement for. That was even.
okay, so Megan, what do you have to say?
Something.
Yeah, I mean, I wish it could be a nice, neat